Good morning. So today's chapter is trademarks. And we all know that trademarks is an important aspect of every business, whether our business is in manufacturing and logistics supply chain, or trademarks that we use to represent what our product is, or want to communicate something about our business, whether it's an e-commerce business, an online business, or an actual brick company that we are producing certain products and offering certain services. Trademarks represent who we are. It could be a choice of a word which represents our brand. It could be a symbol. It could be a sign which indicates the product, which actually brings the kind of awareness for a customer. And the general population can identify who we are as a company and the kind of unique products or services that we provide by just looking at the trademark, by just looking at that symbol or word. So we're going to discuss how important trademarks are in today's business, more so in the online format, in the e-commerce space, in the cyberspace. And what happens if that trademark is not properly registered? What happens if there is an infringement of a trademark? What happens if there is a dilution of a trademark? Somebody is trying to imitate, impersonate your trademark and just diminishes the brand value of your own company. That's what we'll be discussing in today's chapter. So you actually spend a lot of time thinking of a domain name for your e-business because we are talking about cyber law policy and ethics. And in this context, we are thinking about every business trying to have some form of online presence, whether it's Amazon or whether it's McDonald's or any company that you can imagine. And if you're starting your own e-business, you're thinking about a domain name. Now, as you think about a domain name, an accredited registrar has informed you that that particular domain name that you've been contemplating is available for you. But you don't want to spend enough money and time to do your own research because you don't want to copy somebody else's trademark. You don't want to actually use someone else's trademark that already exists. So, for which you need to do your research and for which you have to invest both money and time to figure out if such a trademark actually exists. And if there is some similarity, you want to steer clear and not use anything that's very close to the existing trademark. But for in this example that is being introduced to you, you want to save some time, you want to save some money. So you did not do your due diligence, you have not done enough trademark search, and you've selected this particular name that you think is not being used by someone else, some other company. So this selection of an available domain name may be illegal because you didn't do enough research to figure out if something similar already is being used by other companies. Now, in this case, a trademark owner of the same or a confusingly similar name, but not registered as a domain name, may sue your e-business based on a bad faith registration. So what this particular slide is talking about, how important trademarks are. You might have a legal action taken by another company that thinks you're using a similar name or a domain name for your e-business, very close to something that already exists as an e-business. So you don't want to have legal action against you because you did not do your enough research, you did not carry out due diligence, and you're registering in bad faith, and you can be sued against, and you don't want to get into that kind of trouble when you're starting your own e-business. So and this is like a dramatic introduction of what can happen if you don't take enough care about the importance of trademarks, doing your due diligence, doing your research, and figuring out if there is something similar that's existing or confusingly similar that's already existing. You want to steer clear from that kind of name. You want to take a name that doesn't exist, which doesn't confuse the customer or the general public for your own business that you want to create, or a domain name that you want to create for your e-business. So because trademarks are an intellectual property, they are not just the only part of a company's proprietary rights, because there are other things like copyrights, patents, and trade secrets. Trademarks definitely are one of the important part of a company's proprietary rights. Trademark disputes are among the most common types of litigation because there are several companies across the globe which are trying to imitate what you have built. You've taken a lot of time, a lot of effort in building a trademark, in creating a brand image for yourself, in creating that kind of awareness among customers. And someone else across the globe is trying to use something very similar, take away, snatch away your customers, diminish the value of your brand that you have taken so much pains to build over the number of years that you work for your own e-business. So trademark disputes are pretty common types of litigation, especially in the online environment. Now we are going into the law side of it. A trademark is defined under the Lanham Act of 1976 as a word, name, symbol, a device or other designation, or a combination of all these things that makes you very distinctive in terms of the goods or services that you're offering versus the goods and products and services that are being offered by someone else. So a trademark is a clear identification. It could be a word, it could be a name, it could be a symbol or a device or any other designation or a combination of these designations that make you stand out in the face of competition, which clearly identifies the kind of products and services because that's what they're associating with. I mean, the trademark doesn't have to reflect what type of goods you're manufacturing. The trademark doesn't have to have a direct connection of the type of goods or services that you're offering, but it's distinctive. You're creating that kind of image in the minds of your customers, in the minds of the public and other stakeholders. And it has to be pretty distinctive. Could be a combination of word, name, symbol, device, or other designations. That's the definition of trademarks under the Lanham Act 1976. Now, to be granted the federal registration, the mark must be used, that's for sure. Or you're making a promise in good faith, and you're actually communicating your intent that this particular trademark will be used in the future in doing your business, in carrying out your commerce activities. You're going to use it. And that's the kind of promise that you're making. You're going to use that trademark in the coming future. Now, merely displaying the e-business trademark online does not automatically establish the use of that trademark in whatever commerce you're engaging in, because you need to get it registered. And how do you get the registration of your trademark that you think is very distinct and different from others? You have to go and file your application with the US Patents and Trademark Office, which we generally refer to as USPTO. I'm sure every other country across the globe has their own patents and the process and procedures and the paperwork that has to be submitted to secure the trademark in that specific country or region. So in the US, you have the US Patents and Trademark Office. You go file for a registration after you did your research, after you did due diligence, and making out that the trademark name that you're selecting is not similar, not confusingly similar, is distinct from anything that's already being used elsewhere. So that's the process where you're saying you will use the trademark or you're already using the trademark, but you have to go and finish the paperwork because it doesn't automatically give you an ownership of the trademark, because you have to do the paperwork, file it with the US Patents and Trademark Office, and then you're ready to use it as and when you please as a trademark. Now, what's the business objective? I mean, we are all in the process of creating our own business. Each of you is perhaps already an entrepreneur, or you have plans to be an entrepreneur. You want to establish your own business, perhaps an e-business, because technology gets you to generate money from elsewhere. Technology gets you access to customer bases across the globe. Technology and e-commerce space gets you a chance to connect with suppliers of anything that you want to, procure from them and then start selling them on your e-commerce website. So all of us are capable because of technology that in a short period of time, we can establish a business in the cyberspace, in the online format, in the e-business space. And we all have a business objective and a legal strategy when we think in terms of how we want to protect trademarks. So what are the business objectives? First and foremost, as I was explaining in the past 5 to 7 minutes, that we take pains, we take effort to create a brand image. And you want to secure that brand equity for your e-business and not someone take away the advantage that you've taken so much of effort to build. And one of the very important aspects is the trademark, the name, the symbol, the word, or a designation that you want to use to represent your e-business, or that gets customers or the stakeholders identify who you are, what your business is, what your services are. You want to create that brand image and also secure that kind of brand equity. Also, as a responsible business, you don't want to create a trademark which confuses the customer with something that's already existing. That goes to the second bullet under the business objectives, which is do not infringe or dilute another e-business's trademark. So first, you got to be careful that you're not you know, going out of compliance. You're not infringing on the trademark of another company. You're also not engaging and using a trademark that can confuse customers or dilute another e-business's trademark. You use a distinct, trademark to represent your business, and then you want to secure that because you are going to take pains, or maybe you've already taken pains to build that kind of brand image. What's the legal strategy? You want to get the registration of your trademarks. You just don't want to postpone that because securing your trademark ensures that it belongs to you. And if somebody else is using a similar trademark, you can actually file a law case against them. You can sue them for infringement, or you can also sue them for diluting your trademark. So there's a legal strategy where you're always careful about doing the registration. You're constantly vigilant to assure there is no trademark infringement or dilution of the trademark that you rightfully own. So those are the business objectives and the legal strategy that we are concerned with. Whatever your small business, a large business, or as a multinational company like Amazon, you want to be able to protect your own equity, brand equity. You want to make sure you're not out of compliance and you're not doing something to infringe another e-business's trademark or diluting their trademark. And also, you want to follow the process and do your registration at the earliest and keep a constant watch of those who are trying to infringe your trademark, dilute the brand equity, take away your business. You don't want that to happen. And to do it across the world is not a small task because today's companies, because of the online space again, they're not just operating in one country. They're operating in multiple countries across different regions across the globe. So it becomes even more complex. It's not just the US law that governs trademarks. You have the local country and or region specific legislations that protect trademarks or that do not protect trademarks as intensely as they're protected in the US. And again, as I mentioned in my prior classes, the European law is that much more stringent, much more advanced in terms of comparison with the US law that protects intellectual property that includes trademarks. Now, classification of trademark, let's get deeper into what constitutes a trademark, what does not actually reflect to be a trademark. Anything that is generic, like do not receive protection because they do not distinguish your own business. Suppose when you say instant message or you have mail, these are very generic marks, and you cannot actually get a trademark protection going to the US Patents and Trademark Office or filing for a protection of your trademark because these are very generic marks. So descriptive marks do not also receive protection unless you can prove as an applicant that you can prove that it's somehow inherently very distinctive to what you're doing. So a domain name, for example, like www.ford.com is just a business address on the internet. And if that is not being used to do business or to do actually communicate something that is related to e-commerce or the conduct of business, then you cannot actually secure that domain name as a trademark because that domain name is not distinct, or maybe it's not being, it's not contributing to your business activity per se. Suggestive marks such as the quality of the product or the color of the product, those cannot be trademarked. Suppose I say a Cooper tone for a particular product or service, then I cannot simply trademark it because I'm trying to describe the attribute of the product. It's a very suggestive mark that I'm using to communicate greater detail, greater features or attributes of the product itself. So such suggestive marks cannot be classified as trademarks. The US Patents and Trademark Office is not going to issue you a trademark protection for using certain things like suggestive of the attributes of a product or service. Arbitrary marks exist without any inherent relationship to the product. As I was saying, there are words that companies use which do not mean anything to what they're actually producing or selling or servicing. Like, for example, Amazon has nothing to do with Amazon in Brazil. The Amazonian forest and the Amazonian basin and the Amazonian river, it's nothing to do with it. It's an e-commerce website. So it doesn't have to be related. That's okay. Banana Republic is another example where you go buy your apparel but it's nothing to do with anything to do with the Republic or with the fruit banana. So obviously those are fine. I mean, your trademark doesn't have to reflect exactly what your product is, what your service is, what your store is. So fanciful marks also have no inherent relationship like Kodak or gaming theory, a great game, board game trademarks like Candyland and stuff like that. Recently I was at my dean's home. He has about 2,500 board games, and they have all kinds of names, including Candyland and Tapestry and stuff like that. And Kodak is another example. Does it have any meaning? Maybe it doesn't, but it's in the business of photography and photocopying and instant cameras and stuff like that. So it might mean nothing, but those are okay. You can still trademark them. Like Amazon and Banana Republic, you can trademark those names, even if they don't reflect any of your products, any of your services, whatever you're doing. You can have a very, arbitrary or fanciful mark. If it is not being used by someone else out there, you have every chance to go and finish off your paperwork, file for registration, and with due diligence and with your research, the USPTO will also search from their database to see if something similar exists. And if nothing is, indicative of something being already used, they can issue a trademark for the name that you're filing for. Now, trademarks are actually can include the trade dress. So trademarks have been expanded to now include the trade dress, which could be the color, design, or shape associated with the product. For example, at New York Institute of Technology, we use, say, the blues and the yellows are very specific. No, those are color and design, and you use Rory, the symbols. They're very specific to NYIT. So these are trademarks. In that sense, it includes the color, the design, the shape, with the brand called NYIT. New York Tech has its own trademark. So the trade dress is the product's overall look and feel. The reason why this is so important for this particular class, because of what we are doing in terms of cyberspace. So when you create a very unique web page, the look and feel is pretty much the trade dress. So if you do something very, very specific to the look and feel, then you can trademark it. So if somebody is trying to copy, say, Amazon's look and feel of their web pages, now Amazon can actually sue them because its trade dress is part of the trademark itself. It's just not the name Amazon A to Z. It's funny, have you ever observed Amazon has that A to Z smiley on it? Now, A to Z means they have all the products that you're thinking of. Anything that you want to purchase are available. And they have a nice smiley where Amazon, there is the letter A and there is the letter Z on Amazon. And the smiley connects A and Z with a nice arrow there. It's a nice smiley. So it's just not that name, but the look and feel of Amazon's web pages is what we call as the trade dress. And that overall look and feel is part of the trademark. So if I'm trying to create an Amazon clone and trying to steal from Amazon's business by copying the look and feel, Amazon can take a legal action against me. So most franchises are known by their trade dress, like the example of McDonald's in this case, the reds and yellows. Even if you see it from a far distance, as you're driving, you know McDonald's exists there because of the look and feel, the choice of red and yellow. You don't have to read the word McDonald's there. You know for sure McDonald's is there. So the color, design, the feel, look and feel of your web pages, the choice of shapes that you're using, all this constitutes to what is called as trade dress, and it's part of the trademark that's being protected here. So the color design, the graphics on the website's homepage, you're all experts in that. So make sure when you're doing your e-commerce website, you're establishing your own e-business, you work really well on the color, design, look and feel, and the choice of graphics that you're using, apart from whatever product or service that you're trying to sell, because these become part of the trade dress and they get protected by the trademarks that you're trying to secure. They should assume a secondary meaning other than just being special. They have some meaning that you are able to explain, you're able to document. As long as you do that, you can protect your trade dress, which is integral to the trademark. Now, registering a trademark, we talked about it, trade dress or a service mark. By the way, you don't have to always produce a product and sell it. I could be an educational institution that wants to give a service in education, maybe executive training. Maybe I want to create a web page for myself, my own business, and offer micro credentials. I can provide you training on Python, on R, and AI, and machine learning, and all the wonderful things that you're talking today in fintech, in Bitcoin, all this stuff that are skill based, need based, and you don't have to go to university all the time. You can come to my business, which is a micro credential company. I can work on the name, the trademark name that I want to create. I can make a look and feel which is pretty distinctive, has some meaning to learners who want to take the micro credentials. So that's the service that I'm providing. So here there are no products. The product is now a service in terms of providing you training, micro credentials, so that you can up your skills and competences in the space that is very contemporary, that's not actually covered by a conventional university course or a program. So, an applicant's e-business must first be capable of distinguishing the applicant's goods or services from others. That's very important. Coursera is there, Udacity is there, Udemy is there. How is my company going to be different in offering micro credentials? Is there a change in format? Is there a change in pricing? Is there a change in the delivery, the pedagogy that's used? Is it much more interactive? What else can distinguish my service from Coursera, Udacity, Udemy, and all those companies that offer micro credentials? I'm just running that example through this slide. So it does not have to be a first use to be registered as long no one else is currently using that particular name to represent their business. I can use a specific name. That's where due diligence comes, where research comes. You have to spend time and money to make sure nobody else is using something similar. Now, trademark registration is done by the US Patents and Trademark Office, which is called the USPTO. It'll be allowed because of actual use, or if you made a promise that you're going to use it at a later point of time. As you build your web page, as you build the content for micro credentials, there is good faith that I'm going to use that particular name. The look and feel, the design of the web pages, the rollout of the actual e-business will take a little bit more time as I build the whole e-commerce or e-business pages and also the content that has to be there. The latter use provision is useful in building a website, as I just said, creating a business plan, securing the funding, all that is required to start up your e-business, and also you apply for federal registration before using the trademark in commerce, because you're promising that you're going to use it. Come in the near future, you're going to use it. Now, a search is made by the US Patents and Trademark Office to determine if any other party is using a similar trademark or for a similar business. If not, then there is a distinctive case. Your trademark is very different from anyone else's. It'll be generally registered. Once registered, there is a constructive notice to all businesses out there that your company now owns the trademark. Once you get that form of registration from the US Patents and Trademarks Office, you should be able to display that circle which says your trademark name or symbol or design is now registered, or an SM symbol which talks about a service mark that it's been now registered by the USPTO on your website. So if it's a product, it goes with an R which says registered, or if it's a service, it goes with an SM on your web page saying that this design, this format, this look and feel, this name, this word is now registered. It's protected under the federal registration, and you claim ownership to the registration of the trademark or the service mark. Now, federal registration with the US PTO is prima facie evidence of your trademark ownership. You actually own it now. So the plaintiff must first prove, suppose if someone else is using a similar name, which is confusing to the customers or stakeholders, you can file a complaint. So you as a plaintiff, because you're making the complaint, you have to first prove that you own the trademark, which is the registration that you secured in the first place. In the court of law, with the discretion, you as a complainant can be awarded up to 3 times the damages, whatever has been proved, court costs, and in certain cases, reasonable attorney's fee as well. So you actually, if you're filing a case that somebody else is using something similar, and it's disrupting your business, taking away your sales, or confusing your customers, you can file a complaint. Where you're filing the complaint, you call the plaintiff, and the court will make a discretion based on the ownership that you have for the trademark. Will go into the details, will do their proper investigation, and if they find out that you have lost business, they can award you three times the damages if it is proved, along with the court costs because you're spending time and money having this legal action taken. And in certain cases, even they reimburse you, they get you to get reimbursement of your attorney fee, and that those damages are actually secured from somebody who has infringed your trademark rights. Now, the duration of your trademark, the initial registration is for a term of 10 years generally. This may be renewed indefinitely every time. The mark will be automatically canceled at the end of the 6th year. If you as a registrant does not file in the 5th year an affidavit confirming that you want to continue to use this trademark for all the e-commerce that you're doing interstate or internationally. If the trademark is not used, then there must be a specific reason, and the registrant, that is you should tell the state there's no intent to abandon the mark. Maybe I'm not using it right now, but I don't have an intention to abandon the ownership of the trademark itself. So the e-business and its legal counsel must carefully follow the Lanham Act procedures to ensure trademark renewal. So as a business, if you have your own e-business or you have your own manufacturing company, you have to pay attention to the process, to carefully follow the things that are laid out by the Lanham Act, and you make sure you have the renewal done on a timely basis. For some strange reason, if you're not actually using it right now, you have to communicate the intention that you're not going to abandon it. That's very important. So having a tab on all the amendments, changes in time frames, the renewal processes, your business as well as your legal counsel has to keep a tab on what the procedures are for renewal and do it periodically. Now we're moving to that phase. We're talking of trademark dilution. Now, the Federal Trademark Dilution Act of 1996 amended the Lanham Act to protect companies against dilution of famous distinctive marks in the US. Suppose you have Sony company that manufactures televisions, does the gaming, the PlayStation. They do a lot of things on the television industry, entertainment industry. Suppose you have a company trying to impersonate Sony by simply changing the letter O and making it a U. So instead of SONY, they're trying to sell similar products, maybe not even similar products, something else, but they use SUNY. And they'll make the font look similar, the choice of colors very similar. I mean, that's a real problem in terms of dilution. So the Federal Trademark Dilution Act of 1996 is now going to be able to protect Sony against the dilution. So Sony can actually take an action against this company which is trying to dilute its brand image, brand equity, and trying to damage its own customer base, confusing its own customers. This act defines a dilution as lessening of the capacity of the famous company or mark to be able to be identified and distinguish goods or services, regardless of whether this new company that is trying to do this is a direct competition or not. It doesn't matter. The other business which is doing something to impersonate Sony in this case doesn't have to be perceived as a competition. As long as Sony can prove whatever the other company is doing is lessening the capacity of this famous mark to identify to its customers and stakeholders, distinguish its goods or services. Even if the other company is a small company, say in Indonesia or Australia or somewhere in the Philippines, it doesn't matter. Sony can take a legal action. Now, competition between the owner is not really required. The likelihood of confusion or mistake or to deceive, it's not, we don't have to prove it. Even if it's very similar, that's enough. I don't have to go to every customer to say, hey, were you confused by a different company trying to impersonate our famous trademark or name? Well, I don't have to prove it. So the Federal Trademark Dilution Act of 1996 is a strong enactment in trying to protect the trademarks itself that have been secured by companies and trying to make sure that other companies which are trying to confuse customers or lessen the capacity of this famous company to be able to identify themselves or to identify their goods and services. Even if the other small company is no competition, it doesn't really matter. The the Federal Trademark Dilution Act of 1996 just goes one step further, trying to stop other companies trying to dilute the trademark of a famous name. Now, trademark dilution creates a new federal statutory remedy and differs from the trademark infringement. Now, trademark dilution occurs when a trademark is used by another company, as I was explaining, in a manner as to cause it to diminish its own identity over a period of time. It need not cause immediate confusion in the mind of consumers, but over a period of time, it can cause dilution of the brand equity, brand image, the quality of the product or service, and that can be pretty damaging. So, dilution can take place without consumer confusion regarding the identity of goods, even when the mark is used on unrelated, non competing goods or services. Suppose the other company, which is using SUNY instead of Sony, can be producing, say, detergents, or could be manufacturing something, stationery, school bags. It doesn't matter, but if they're using that particular name, that's enough for Sony to file a legal action. So that's about trademarks. If you have any questions, please feel free to ask. We'll have, as we talked about.